We're embarking today on our 17th lesson in the truth about personal finance, what the Bible and the historic academic research say is the best path to God-honoring financial independence. Our guiding verses for this study are Job 22:21. Submit to God and be at peace with him. In this way, prosperity will come to you. And from Hebrews 11:1, faith is being sure of what you hope for and certain of what you do not see. And from Deuteronomy 8:17 through 18, you may say to yourself, my power and the strength of my hands have produced this wealth for me. But remember the Lord your God, for it is he who gives you the ability to produce wealth. And from Job 21:16, but their prosperity is not in their own hands. I'm Ron Fisher, and I'll be giving today's study. Our study today is on estate planning. Isaiah 10:3 is a guiding verse for this study. What will you do in the day of reckoning? Where will you leave your riches? And from Ecclesiastes 5:13 through 15, I have seen wealth hoarded to the harm of its owners, or wealth lost through misfortune, so that when they have children, there is nothing left to inherit. Everyone comes naked from their mother's womb, and as everyone comes, so they depart. They take nothing from their toil that they can carry in their hands. As everyone comes, so they depart. And finally, from 1 Chronicles 22:5, so David made extensive preparations before his death. Why have an estate plan? Cheryl Kirsten writes, a smart estate plan lets you stay in control. Without a plan in place, you don't get to choose who gets everything you've worked for your whole life. The Bible says in Ecclesiastes 9:12, moreover, no one knows when their hour will come. And from Psalm 39:5 through 6, everyone is but a breath, even those who seem secure. In vain they rush about, heaping up wealth without knowing whose it will finally be. If you want to be the one making those decisions, then you need an estate plan. And when there are so many factors outside of your control, it's important to spend time planning for the things you can control. Stacy Johnson and Miranda Marquardt write, the reality today is that 45% of people over 55 years of age don't even have a will. From 2 Kings 21, we read, this is what the Lord says, put your house in order because you are going to die. And from Psalm 90:12, we read, teach us to number our days that we may gain a heart of wisdom. What is estate planning? Estate planning is the process of creating legal documents to specify how and by whom your assets will be handled in the event of your passing, or if you are unable to make decisions for yourself. An estate plan involves having a will, setting up a trust, selecting beneficiaries for retirement accounts and life insurance policies, and how you title ownership of assets, including your home. In Ezra 4:22, we read, be careful not to neglect this matter. And from Psalm 49:16 through 17, do not be overawed when others grow rich, when the splendor of their houses increases, for they will take nothing with them when they die. The last will and testament. A will is a set of instructions explaining how property owned in your name should be distributed after your passing. It also names the executor of your estate and a guardian for minors if needed. When choosing an executor, you want to ask somebody who is detail-oriented, maybe somebody in your family who's a lawyer, accountant, or somebody really trustworthy. It wouldn't be a bad idea to name a contingent executor in the case of onset of dementia or the death of your first executor choice. In Hebrews 9:16 through 17, we read, "In the case of a will, it is necessary to prove the death of the one who made it, because a will is in force only when somebody has died. It never takes effect while the one who made it is living." Marilyn Lewis writes, "A will gives you the power to decide what is the best interest of your children and pets after you're gone, and designate any assets you are leaving for their care. It also can help you determine what will happen to possessions with financial or sentimental value. In the absence of a trust, your will is sent to probate court, and these proceedings become a matter of public record, with the ability of individuals to dispute the validity of these instructions in light of any other relevant information. It is important to keep private information, such as passwords, out of your will, as that information could become a matter of public record." The Revocable Living Trust. The Revocable Living Trust is one often overlooked estate planning tool. Trusts offer more control and privacy than wills, and they can help make your estate plan more flexible. A trust passes assets to heirs while avoiding potentially expensive and time-consuming probate court. You name a trustee, perhaps your spouse, family member, or attorney, to manage your property. Unlike a will, a trust can be used to distribute property now or after death. You should find a qualified estate attorney to help you create a revocable living trust. Durable power of attorney. It will be important to have a power of attorney in place. A power of attorney is a person who is designated to manage your decisions when you are no longer able to do so. Don't put off choosing someone, because you must be legally competent to assign this role. There are two types of power attorneys you need to designate. The first is a financial and legal power of attorney who manages decisions surrounding your finances. A second power of attorney is a health care power of attorney who is designated to handle decisions regarding your medical care in the event you become incapacitated. One of the most sensitive topics to discuss is what will happen to you if you become unable to manage your own estate, whether temporarily or permanently. It's important to have a plan in place so your financial and medical wishes are carried out. A living will. A living will and advanced medical directive outline what your preferences are concerning medical treatment in terminal situations. A living will details instructions concerning end-of-life care only. A living will allows you to explain in advance of terminal illness what types of care you do and don't want in the case you can't communicate that in the future. It is strictly a place to spell out your health care preferences. You can say as much or as little as you wish about the kind of health care you want to receive in your living will. Designate beneficiaries. Make sure to review your beneficiary information and all retirement plans and insurance policies. Beneficiary designations are important. Did you know you need to designate your IRA beneficiaries as per capita or per STRPS? Getting it right can make a big difference in how your wealth is transferred and whether it's passed down the way you intended. With the per capita designation, assets are divided equally among surviving co-beneficiaries, which means nothing will pass on to a deceased beneficiary's heirs. With STRPS designation, if one of your beneficiaries is deceased, their portion of the will go to their surviving children. In Ezekiel 46:16, we read, "This is what the sovereign Lord says. If the prince makes a gift from his inheritance to one of his sons, it will also belong to his descendants. It is to be their property by inheritance." Make sure to remember to update your beneficiaries as needed after big life events, such as births or marriages. These beneficiary designations take precedent over instructions in a will. Proper titling of assets. It's important to review that any assets jointly owned with your spouse are properly titled the way you want, because how the assets are titled may take precedence over instructions in your will. Digital Asset Trust. Marilyn Lewis writes, "You can use a digital asset trust to decide what to do with your electronic property, including your hard drive, digital photos, cloud storage, and online accounts such as Facebook and Google. It is wise to create a separate list of your passwords." Letter of intent. The letter of intent is an opportunity to write instructions, requests, and important personal and financial information that don't belong in your will. This may be a good place to give detailed instructions about how you want your funeral or memorial service to be performed. An attorney is not needed, as this letter won't carry the weight of a will. Estate plans need to be reviewed regularly. An estate plan isn't something you can set and forget. You want to make sure that your intentions haven't changed and you've included the right people. If it's been 5 or more years, it's time to review your estate plan to see if any updates are warranted. You may also want to check whether there have been any changes to the tax laws that could affect your plan. If you or your family have experienced any major life event, it's worth revisiting your plan. Protect your estate from taxes. Cheryl Kirsten writes, "Another benefit of a revocable living trust is if you have substantial assets or wealth, a trust can be a way of providing tax savings. When tax laws change, it is important to review your portfolio to see how it might be affected. Armed with an effective tax strategy, you can avoid making costly mistakes that could eat into your estate. Planning for the estate taxes and any federal and state inheritance taxes is an important aspect of estate planning." Minimize inheritance taxes. Cheryl Kirsten writes, "You can minimize inheritance taxes by giving money or property to family members or others during your lifetime. You can, 1, Make annual gifts of up to $16,000 each per gift recipient, or $32,000 by a married couple. 2, give an unlimited amount to charity. 3, contribute to a loved one's 529 educational savings plan. You can make up to 5 years of contributions at one time without incurring a federal gift tax. 4, pay any amount toward another person's tuition or medical bills. You must pay the tuition directly to the institution on behalf of a loved one, and qualified medical payments must be made directly to the provider. 5, invest in a Roth IRA. The primary benefit of a Roth IRA is that you pay taxes now, so your beneficiaries won't have to pay them when they inherit your Roth IRA. Legacy planning. Aaron McLean writes, once you have an estate plan that captures where your assets will go upon your death and who can make financial and healthcare decisions if you become unable to do so, it's time to start thinking about legacy planning. This is where you'll shift your focus from finalizing legal documents to preparing your family to inherit your wealth and execute your wishes. Consider this question: how prepared are your loved ones to inherit your wealth if something unexpected were to happen tomorrow? This simple question reinforces the importance of legacy planning. The top reasons families don't succeed in transferring their wealth are 60% is lack of communication, 25% is inadequate preparation, 15% are other reasons such as lack of mission, taxes, or legal. Proverbs 27:24 reads, "For riches do not endure forever, and is not secure for all generations." The key to successful wealth transfer starts with regular communication about your financial intentions. Your family should know what to expect when you pass away, including how they can best protect your wealth and carry out your financial legacy. We read from 2 Kings 17:41, "To this day their children and grandchildren continue to do as their ancestors did." If you haven't already set aside time with your partner to get on the same page with long-term goals and ensure you're both prepared if life brings an unexpected situation your way, once your kids become young adults, bring them up to speed on your family's long-term wealth plan. Scheduling meetings at least twice a year is a good place to start. Legacy meetings go a long way in creating clarity around your decisions. Educate your loved ones to alleviate a sudden financial burden should something unexpected happen to the family financial lead. This can be done by involving your spouse in meetings with any and all of your financial team, including your certified financial planner, your certified public accountant, and your estate planning attorney. Knowing that they have trusted professionals that can turn to can be extremely comforting if they're not equipped to take on the responsibility alone. Along with that, teaching them the basics of financial concepts and investing principles they'll need to carry out your legacy will prepare them for responsibilities that lie ahead. A list of important documents. Make sure your family knows where to find everything you've prepared. Be sure to keep a secure, easily accessible record of your accounts and include the contact details for any financial associates. you consult with, including financial advisors, tax planners, estate planners, trustees. Make a list of documents, including where each is stored. Include papers for bank accounts, and you should make your bank accounts payable on death to a beneficiary. List of bills and accounts, include contact information and the account numbers, life insurance policies, real estate deeds, pension and retirement accounts, stock, bond, mutual fund, ETFs, annuities, birth and adoption certificates, and divorce records. Consolidating your assets and capturing the priority of financial decisions can help to simplify the process of resolving your estate in an efficient manner and be much appreciated by those who survive your passing. Conclusion. An estate plan allows you to choose who gets everything you've worked for your whole life. An estate plan involves having a will, setting up a trust, selecting beneficiaries for retirement accounts and life insurance policies, and how to title ownership of assets, including your home. A will is a set of instructions explaining how property owned in your name should be distributed after your passing. It also names the executor of your estate and a guardian for minors. You need to name a power of attorney for your legal and financial decisions, as well as a healthcare power of attorney. In the absence of a trust, your will is sent to probate court, and these proceedings become a matter of public record. To avoid probate court and the public record, establish a revocable living trust. A trust passes to heirs while avoiding potentially expensive and time-consuming probate court. A living will, an advanced medical directive that outlines your preferences of medical care in an end-of-life situation, is important if you are unable to communicate. Action steps. Do you have a will or revocable living trust? If not, make it a priority in the next 3 to 6 months to get a will or revocable living trust completed. Your heirs will greatly appreciate your diligence in this matter. 2, have you considered a legacy plan for preparing your heirs for receiving and investing their inheritance? If your heirs are young adults, it is time to start preparing them, first by educating them in financial planning and your legacy goals.